Welcome to Wills and Estate Planning. I'm Amber Cohoon, an attorney in Texas. I help clients all over Texas in business, real estate, employment law, contracts, estate planning, and probate. If you're watching this, then you are most likely considering scheduling a consultation about estate planning with our firm. This will cover a lot of basics so that when you are in the consultation, we can cover more specifically your situation. So please feel free to take notes. And at the time of the consultation, we will go over any of your questions that you may have. This is for informational and educational purposes only and should not be considered legal advice. What is an estate plan? So this is a plan that is comprised of many documents, and they cover what happens during your life if you are unable to make decisions for yourself and after you pass away. An estate plan tells your family or your loved ones or who you've designated what you want to have happen to you and to your estate after you're gone, when you can no longer let them know. The word estate is used very often, and we'll talk about that. What it means is it's actually your total amount of assets minus your current liabilities. So it's your net worth minus your liabilities that you may have. That what's left over that's your total estate. So let's say you have $100,000 in assets, you have $20,000 in liabilities, so your estate value would be at $80,000. Your estate is made up of assets that will pass through your will and some that will pass outside of your will. And these assets include any real estate or personal property. Personal property are things that can move, like your vehicle, furniture, jewelry, clothing. And real estate is anything to do with the land. So if you have vacant land, your home, any buildings, oil and gas, mineral rights, anything like that. The assets that usually do not pass through your will are going to be life insurance policies, some investments, and maybe bank accounts. Usually those companies administer, to your designated beneficiaries. At the time when you open them, they usually have you designate that. Especially with a life insurance policy, they do that. And then those could pass directly to your heirs or your beneficiaries upon your death. By listing your beneficiaries on those accounts, it's the best way so that your family does not have to wait to have access to those accounts or funds. Creating an estate plan and doing it with a goal to avoid probate will be the most beneficial to make sure that your family is taken care of after your passing. A lot of people come to me because they have a will or they want to update it. And after we discuss it further, they realize that just having a will doesn't protect them and their assets from going through probate after they've passed. When there is only a will, or if they have no will, then your loved ones will have to go through probate, which is a court proceeding that can last for many years. Without a will in Texas, your heirs are determined by the Texas Estate Code and who gets what. So if you have a non-traditional family or loved ones that aren't necessarily your legal heirs, they would not be able to inherit your property. It would go to your legal heirs according to how the intestate laws state. And so having a will is the bare minimum, but to make sure that your assets are protected and that your family is really taken care of, it's best to have an estate plan in place so that you can avoid probate. Unfortunately, most Americans die without a will, and each state has their own intestate laws. And so if you die and have property in multiple states, then unfortunately your estate will have to go through probate in multiple states, which is a disaster. And those of you with elderly parents, that is, a great burden that's shifting to our population as it ages. And our parents are getting older, and as they may be going into long-term care facilities, hospice, nursing homes, or maybe you're bringing them into your own home to take care of them as they age. So it's important to have a plan in place, and you can't make those decisions for your parents, but you can talk to them about the importance of having a estate plan and urging them to talk to an attorney about their desires. And that's a good first step to really understand what they need to do. So if everything's in place with your estate or with your parents' estate, then your loved ones will know what to do after you pass. They'll know how you wanted things to be taken care of, and it will help eliminate and alleviate any disputes between siblings or other family members. Now, not always, but usually if we do an estate plan, we always encourage our clients to tell their loved ones what their plan is and what they have set in place so that they can communicate their desires, and if there's any disputes, that they can be handled during their life. So it's not a surprise to their loved ones after they have passed. And it also allows, after you've passed or your parents have passed, that period of grieving. So that can occur without the additional burden of trying to figure out what you have to do now or your family has to do. And so many people are having to deal with this with their parents or loved ones that have passed for the very first time, especially because of COVID. We had a lot of unexpected deaths at that time, and it was very overwhelming for so many people. And so it's important to talk to your loved ones and your parents so that you can get a plan in place. At Cohoon Legal, we offer two plans. One is a simple estate plan, which only has the last will and testament, a medical power of attorney with the HIPAA authorization, and a durable power of attorney. So that is the simple estate plan. And then we have our complete estate plan, and that includes the last will and testament, a declaration of guardian if later incapacitated, and if you have minor children, we have a declaration of guardianship of your children, appointment for disposition of remains, a durable power of attorney, a medical power of attorney, and a HIPAA authorization. There are optional documents that we can also include. One is a directive to physicians for your medical care, a transfer and death deed, and we have trust, which can begin at the time of signing during your life, or we can have them begin after your passing.
And so the will is going to disperse your assets in the way in which you desire or put in the document. A medical power of attorney is going to designate the agents that will be able to make decisions on your behalf when you are unable to make them regarding any medical decisions. What can happen with the medical power of attorney is it can go in and out. So let's say in the morning you're in the hospital and you're coherent, you can make decisions, but then you're about to have surgery. And so then you aren't able to make the decision. So while you're in surgery, if they needed a decision to be made, they would rely on that medical power of attorney and that agent that you have listed. But then when you're out and you're back, you would then get it back. So the medical power of attorney has a lot more flexibility because it really is dependent upon right then and there how you're able to, or if you're able to make decisions. The durable power of attorney is over your assets, your real estate, if you have any business, investments, all of your financial assets, basically. And there is a list of the different assets. And so you can have multiple power of attorney if you don't want one person controlling all of that, once you're unable to make those decisions. Or you can have just one where they do all those things. And so the difference with the durable is that it only goes into effect. You can make a choice. You can have it go into effect when you sign it. So you're, able to make decisions, but you might want to have someone else making decisions over certain things while you're still able to. I don't always recommend that. And it really is dependent on the situation when that might actually be a good, solution. Most of the time, it's going to come into effect once you are unable to make decisions for yourself. And that's going to be determined by medical doctors. And so you will actually have a kind of a diagnosis or a statement from multiple doctors that say that you're incapacitated, that you need to have someone else making your decisions for you. And so that's when that durable power of attorney would actually come into play. If you don't have those two things and you are at that point where you can't make decisions, then the alternative is actually having to go through a court proceeding called a guardianship proceeding. And that is through court. It's expensive and it takes a long time. And so that's why having the medical power of attorney and durable power of attorney are so important, because they basically function in that way without having to go through the court. The other thing you have that we usually do with the medical power of attorney is a HIPAA authorization because of health, privacy laws that basically allows people to have information and access to information. It doesn't mean they make decisions, but it allows them to have access to that information about your health at that time. So if you were sick or something, the doctors would be able to talk to your family. The other document is an appointment for disposition of remains. And so that is going to be a document that tells your agent or your loved ones what you actually want to have happen after you pass away. So do you want to be cremated? Do you want a burial? Do you want to be your ashes spread? As detailed or as minimal you want to be, that's where you put that. Or if you already have, some people already have bought like a plot or something like that, and without telling your loved ones, they can pay double. Unfortunately, if they don't know, or you already picked a funeral home that you've prepaid your expenses, well, we would put all that information in there so that your family would know, and they wouldn't have to make that decision. Because when someone passes away, especially in a hospital, they're having to make those decisions within like an hour or so of someone's passing. They're like, where do you want the body to go? What funeral home? And it can be very stressful if they don't already have that information and they don't already know what you're wanting to have happen. The other thing is a declaration of guardianship in the event of later incapacity or need of guardian. So in case something happens, that the durable power of attorney and the medical power of attorney, which is it's rare, but just in case it does happen where you actually need someone to take over and be a guardian, this is your chance to actually say who you want to be the guardian. And it could be a guardian of your like well-being, like taking care of you where you live, and you can have a separate person do your finances, or you can have them both do both parts, so you can be have more control over that. One thing, if you were to say that you just had one house and you were buying and selling other land, but you just had the one house that you were probably going to stay in until you passed, there's something called a transfer on death deed, which is a document that we put within the property records, and it designates who you want to be the beneficiary and get that house, and so that it would pass outside of probate. And it's a much smoother transition after your passing, because probate, if you have a will, the will has to go through probate unless all of your assets have been taken care of in a way that probate is not necessary. So one of those for a home or other real estate property is through a transfer on death deed or a trust. Transfer on death deed is simpler. It's cheaper, but it's not as convenient if you're going to be buying and selling different real estate and you're not staying in the same home. So it just kind of depends. But the trust is a document that basically allows you to control your assets after you've passed. And you can control, it can come into, you can create it through a will saying that all of your assets would go into a trust upon your death, or you can actually have a trust during your lifetime, and that's called the inter vivos trust, and you put your assets during your lifetime into it, and that includes real estate, cars, anything. Basically, the ownership, like a title for those vehicles, would be in the trust name. But once you decide and you fill out an intake, which is pretty detailed, you'll be picking the people who you're assigning each of those documents, the rights. And then you talk about, it asks questions about what you're wanting to do with your estate, who you're wanting to leave it to. And then through those questions, it helps guide what type of documents or what type of, if a trust would be necessary or if not. Or if just a estate plan and doing like a transfer on death deed to avoid probate is the better solution. And then what we do is you fill the intake out, you send it to us, we prepare the documents, we send them to you to look over. So if you see any mistakes or anything like that, then we get it all prepared, and then we have an actual signing where we'll need two witnesses that are not benefiting from your will or any of those documents. And I or someone else will be the notary and we'll sign all the documents. And then if we have to file anything with the county, we'll do all that for you and get it all prepared. So that's all kind of included.
Thank you for listening to this wills and estate planning presentation. You can directly schedule a consultation as you see on my website at www.cohoonlegal.com, or you can call our office at 817-632-3244, and you can speak with one of our staff to help you schedule or if you have any other questions.
As a reminder, if you have already booked an estate planning consultation with Cohoon Legal, check your email for a short questionnaire to fill out. The completion of this form confirms your consultation.